The curriculum review report, which I hope everyone's had a chance to pick up a copy of at the back, is the result of a process which was underway for quite a long time at UNSW Law School. And maybe I'll just say something about that process before we talk about the substance, which I'm sure the Chief Justice will be doing. It's a process which I was delighted with the way that it went in the law school in a couple of ways. In that this was something that, well, just the fact that we managed to do it is a pretty major achievement. The Chief Justice was mentioning there's a new history of Monash Law School, which has just come out. One of the differences between our recent histories of two law schools, which are very close in lots of ways, is that Monash, like others, have tried to do big changes and haven't managed to get them through. And the reason that we've been able to get through what are pretty significant changes at UNSW has been the very special culture which our law school's got of an ability to disagree about things, but then to agree that we're going to get somewhere and go on and do things. And that's really very much what happened with this report. A lot of colleagues put together very different views and agreed that we were going to get to an outcome. The other people who were involved in it, I'm delighted that the people who were then the presidents of the Students' Law Society are here tonight, Leslie Fone and Angela Kintilmanis, because the students just played, as they should do in universities, played a crucial role in the way that we redesigned the curriculum. And they just played such a constructive and positive part. I'd just like to thank them again for that. The background to the content of the review, it came from a couple of major things, I guess. One was that we spent a lot of time talking formally and informally to the employers of our graduates in the courts, in the law firms, in governments, in the public sector and so on, about what they thought of what we were doing in terms of educating our students, and got immensely useful feedback. And it was wonderful that there was so much interest in telling us what they thought we should be doing. And then secondly, we were looking at trying to get what the best practice in US law schools is. And some of us spent a fair bit of time looking at what was happening in the US. And the thing that was very lucky, actually, but it was interesting to me, was that there was a real coming together of those two perspectives, that what people in our stakeholders were telling us we should be doing was very much what was being recommended, rather than possibly being done, but certainly being recommended in the big reviews of American legal education, like the Carnegie Report. And those things are just in the sort of slogan level, are to obviously to respond to the changes in law in terms of the shift towards regulation and legislation, and the importance of statutory interpretation, the importance of dispute resolution, as well as what happens in courts, those changes, and the changes towards the internationalization of law. And that's become a major part of what we do, and I'll maybe talk later about how we've gone about it. But then also, that not just what you teach, but how you teach. And a major commitment in the new curriculum is about the shift towards, it must be a ghastly word in legal education, experiential learning, but it sums up all of that stuff, which is about getting students learning to see the law in practice by getting them out of the classroom. And the Chief Justice and I were just talking just before we started about in many ways the major changes to legal education come from people responding against the awful experiences that they had as students, and that's certainly that was the case when UNSW Law started, I think, and I think it's continued to be that, looking to see how things can be better for our students. And so very much, as the title of the review report talks about getting students out of the classroom, seeing law in action and law in the world. So to launch the UNSW Law curriculum review, And it's my great pleasure to call on the Chief Justice.
Thank you very much, David. Your Honours, there aren't too many of your Honours here. I see Justice Ma. One of his colleagues, Justice Baston, who's on the Advisory Council, sent me a note of apology. I understand that he and Justice Leeming are presenting a seminar on administrative law to their colleagues, and I did suggest to him that, thank him for his apology, but suggested to him that if he put the proposition to his colleagues that 99% of administrative law is rationality as a criterion of validity informed by the internal logic of the statute, he could finish the talk in 5 minutes and still make it for the launch, but he seemed to think that wouldn't cut it for some reason. This evening's event marks a significant change in direction in the law curriculum offered by UNSW Law. The story of the process which led to the adoption of the new curriculum and the issues thrown up by that process are reflective of some of the hard questions facing Australian legal education today and the hard institutional work that is required to provide working answers to those questions. Curriculum review is not a topic which readily engages the passions of the innocent bystander, so when I sat down last night to read the law school's account of the process and its outcomes, I did not hold high hopes of being swept along by the narrative. My heart sank briefly early in the work when I came across a reference to UNSW Law having been at the cutting edge of legal education in Australia and breaking the mould which Australia had inherited from England. This mix of two-dimensional and three-dimensional metaphors in the one sentence would have been unfortunate had it not been for the fact that I just finished watching an episode of Doctor Who, in which creatures from a two-dimensional universe somehow engage with our three-dimensional universe and suck innocent passers-by into carpets and walls. So I forgave the dimensionally mixed metaphors and moved on, and I'm glad I did. For reading on, I began to appreciate the complexity and magnitude of the task which UNSW Law has set for itself and undertaken over the past 3 or 4 years in its wholesale review and reform of what it teaches and how it teaches it. Indeed, after reading further into it and observing the engagement of curriculum reform with competing theories of legal education and the priorities to be given to various elements of it and the external regulatory and quasi-regulatory constraints which affect curriculum design, I began to find the story of the review quite gripping. Now, this may be a matter of concern to some who think that if you find curriculum review gripping, you haven't got a life. The fact is, curriculum review is a battlefield in any area of education, and acutely, I suspect, in the field of legal education. The battlefield is populated by articulate, passionate, and persuasive proponents of different and sometimes conflicting visions of what law schools should be for and what they should do. The question of purpose in legal education must be asked, and has been asked in the course of this review. It has been called strikingly by one writer about legal education a lost question. Law schools, of course, are not simply there to make money for the universities or to enhance institutional prestige. Any institution worthy of designation as a university must seek higher societal purposes. And in relation to, in that connection, Harold Coe, formerly Dean of Yale Law School, emphasised what he called the moral dimension of legal education when he said in 2006, "I don't believe it's our job simply to bless the status quo. We stand for principles about what the rule of law should be. As a law dean, I think that law schools are not just professional schools. They are institutions of moral purpose. We must speak up for the rule of law when someone is threatening it, because if we don't, who will?" Of course, moral purpose is of little avail if its proponents are not equipped with the practical tools to give effect to that purpose. The redesigned curriculum seeks to engage with the doctrinal and theoretical as well as the ethical and experiential dimensions of legal practice, and in an integrative fashion. The process, as I have read about it, has not been an easy one. It has had to engage with different visions of legal education within the academy, among staff and students, and outside, among alumni, the legal profession and the judiciary. And all of those groups were the subject of consultation and to a greater or lesser extent actually participated in the process. There are some interesting little subtexts in the account of the consultation process, particularly the engagement with the legal profession. Although, as the authors of this review history point out, academic lawyers consulting with practicing lawyers sometimes expect to be given advice about the need to make courses more practical and to cut out the luxury of interdisciplinary explorations. This proved to be an inaccurate stereotype. If I can just quote one little passage from the history, while we did receive some advice about our teaching of equity, long a preoccupation of some commentators, and I interpolate especially in New South Wales, where the judicature acts are still a bit of an innovation, most of the lawyers had a gratifyingly progressive and positive view of the role of university legal education. They did not want us to be a trade school. They saw the teaching of practical legal skills as something which for which they were happy to take responsibility. Instead, they wanted law schools to produce graduates with higher level skills, analysis, communication, problem solving and critical thinking. They wanted graduates capable of practicing law as ethical professionals. They also often stressed the need for young lawyers to be able to see law in its increasingly important global context and to be able to work with international clients and partners. This entails social and cultural skills, not just extended doctrinal knowledge. And from my own personal experience and observation, that has the ring of reality about it in terms of perspectives in the profession. As I think David hinted at in his remarks, there was within the law school a degree of substantial and strongly held difference of opinion about competing proposals, and the most dramatic difference seems to have been concerning the study of criminal law and procedure, where the one proposal was being pursued by the head of the law school and the other by the dean. And this was the sort of dispute which, as the review history notes, quote, at other law schools has caused endless grief, unquote. In the event, it was resolved in an atmosphere of mutual respect, and the process moved on. The process has yielded some interesting and thoughtful approaches to course design and particular practical outcomes. One I have in mind that I observed is the division between the core subjects and the elective subjects, and the very difficult question of just how you design your electives and how you cluster them, and the problems which students face in deciding which electives they should seek. With the core subjects it's easy, they have to do them. With the electives, my God, they have to make a decision. And what's the framework for people who, after all, haven't had no experience of what works outside and what doesn't, to make within which they can make their choices? And that concern has been recognised and has resulted in the creation of the Office of Director of Senior Studies, which I understand begins this year, or began this year, which provides guidance to students, among other things, about elective choices, as well as general career advice in respect of legal careers in a broader sense. In devising the new curriculum, UNSW Law has had to navigate a number of constraints, including resources, professional accreditation, the dead hand of the priestly 11, government regulations, and of course the managerial framework of the university itself. There's a whole book written about that called Privatising the University, the Case of Law by Margaret Thornton, which I think David is familiar with, and which I launched a few years ago, which is a wonderfully readable rage about managerialism, and has some wonderful quotes from law deans around the country, including one from one of the what is called the limestone universities, as I am audited out of my mind, reflecting upon that dean's interaction with the university management. On the resources front, while you have borrowed from and been inspired by the work of American universities in their curriculum designs, you're also operating in a very different resource context. And as the history points out, UNSW Law has had to enrol 4 or 5 times as many students as a top United States law school, and that leads to difficulties in managing scale, particularly when you're looking at change. Rearranging the teaching of 500 students is a very different exercise from rearranging the teaching of 100. Another constraint is the involvement of staff themselves in what is described as, and I think correctly, the intense innovative work required in the fundamental curriculum review, and the competition that exists between that commitment and the commitment both to teach the ongoing courses and, of course, to meet with other demands, including the publication of scholarly works and the endless exercise of acquiring grant-based funding. The product of the redesign has some important features which I would like to mention briefly. Firstly, a strong emphasis on statutory interpretation in the teaching of formal skills and in working with statutes in subjects which were previously treated largely as case law subjects. And there are few legal problems which come before practitioners or courts today which do not have a statutory dimension. And that is so whether they present primarily as problems about contract, tort, property or equity. Furthermore, there are very few cases in public law, particularly judicial review of administrative action, which do not involve statutory interpretation. I once said to somebody who was maybe involved in the drafting of additional wording in the Migration Act, every new word is a jurisdictional error waiting to happen. When the constitutional validity of a statute is challenged, the first task is the interpretation of the statute. More often than not, any given legal problem will involve the intersection of more than one statute. The second aspect of the feature of the design is the emphasis on the resolution of conflict outside of the litigation process and the removal of the rather dismissive label alternative dispute resolution. And I think that's an important recognition of the very important role that conflict resolution beyond the litigation process plays in real life legal practice. Although I have strongly resisted and still do the categorisation of the courts themselves as just a species of dispute resolution service, which you sometimes see in publications by bodies such as the Productivity Commission, and a failure to recognise the unique role of the courts as a third branch of government with a public affirmation role of the rule of law, which is not the functional purpose of other forms of dispute resolution. Then there's the emphasis on legal research and writing as a set of learning units attached to various subjects within the course. I think that too is very important. And fourthly, the recognition of the increasing internationalisation of legal practice. And that has a couple of dimensions. There was a study carried out by ILSAC a couple of years ago on the internationalisation of the law curriculum. And one of the challenges with which they had to deal was that there's a big end of town notion of internationalisation and there's a smaller end of town or suburban notion. And for some people, their practices will never see somebody walking through the door who's involved in an international commercial arbitration or an investor-state dispute resolution process. And yet, have to practice in a domestic law context where an increasing amount of our domestic law is informed by international law of one kind or another. You look just, for example, in the area of criminal law, look at drug trafficking and possession and so forth. That used to be in the in the sphere entirely of the states, apart from prohibitions on importation and exportation and so forth of drugs and trafficking of imported drugs under the Customs Act. Now, the Commonwealth Criminal Code has brought in a wide range of offences pursuant to conventions, which is a party which overlap with state criminal laws in that respect, and some of these issues were discussed in the case of Mopsilla in Victoria, which has of course provided an endless source of work for legal academics trying to discern the positions of the various judgments and their differences. So we see that internationalisation having to be addressed in a variety of ways and for a variety of purposes. I'm delighted to see its recognition in this course. There is also an emphasis on ethics and professional practice, which is to be linked to experiential learning through the in-house legal centres and clinics, and you already have an established track record in that regard, and through the promotion of participation in local and international internships. There are also a number of what I think are called vertical themes throughout the curriculum: Indigenous legal issues, human rights, justice and the rule of law, gender, class, race and disability, environmental issues, interdisciplinary, international and comparative perspectives, corporate and commercial law issues, personal and professional development and ethics, and experiential learning, which is described as a fundamental aspect of the new curriculum. And I have to agree about David's description about common experience as law students. I must say I found the study of law, with all due respect to many good teachers, extremely tedious. My recollection of the Company Law course, as it was then called, was readings from chapters of the Company Law Act of 1961, Companies Act 1961, by an aged practitioner who did little more than tell us what the section said. It was a useful starting point, but, and it was not until I started my articles, even then unsure as to whether I wanted to pursue a career in law, that engaging with real people with real legal problems just caused my motivation about the law and legal practice to multiply by a factor of a large number of orders of magnitude. And of course, in those days, there were no clinical experiences in legal education. Now we know that generally there's a much greater emphasis on it. Those vertical themes which are mentioned provide opportunities for many interactions, and I just wanted to do a little thought experiment. One example which comes to mind would be to set an exercise, and it comes out of a theoretical problem involving this sort of a practical problem, involving Indigenous groups which have to manage land and property. You could have an exercise either theoretically or in a real-life situation requiring students to devise a manual for the boards of incorporated Indigenous groups managing land or funds derived from land use agreements. The object of the manual would be to set out in a comprehensible and practical way a working guide to the responsibilities and obligations of such bodies. This would almost certainly involve a consideration of statutory powers and duties, contractual rights and obligations, and fiduciary and other equitable obligations. The preparation of such a manual would undoubtedly be an exercise in which theory, practice and experiential learning would intersect. A subsequent challenge would be to explain it to a group to whom it was directed. That and many other possibilities are opened up by the interacting themes of the new degree course. Well, the curriculum review has been a massive project. It's confronted issues which all law schools in Australia have to confront, and I congratulate UNSW Law on the work it has done and the resource which that work provides for the development of legal education in Australia generally. I'm not sure whether I'm going to make a declaration about this, but if I am, I do.
Well, I wasn't sure when I did the introduction whether I should say anything about the content, because I didn't know what the Chief Justice was going to say. I don't need to say anything now because he did such a wonderful summary of what it's been about. So thank you for that very, very generous launch of our curriculum review report. I'd just like to finish just by thanking some other colleagues who are here tonight. So, I mean, this has been, like we've been talking about, it's been very much a collective work from the law school, but some people have played a particularly vital role in getting the curriculum review through. I particularly want to acknowledge Brendan Edgeworth, who was head of school when all of this happened. Prue Vines, who has been our first year director for a long time, and has been a sounding board and a powerhouse behind getting this review, actually getting the review report done, apart from everything else. And Justine Rogers, who, one of our younger colleagues, who's been the person who's taken on rewriting, redesigning our ethics course. Alex Steele at the back, who's as Associate Dean Education, has done so much work across the whole review process. Mara Sanrock, Director of our JD programs. Colin Pickett, who's been the back, our Associate Dean International, who has been the driving force behind the course Law and Global Context, which is, I think, one of the really innovative parts of the curriculum. So many people here have contributed to that, and it really is a collective enterprise. So I'd like to thank everyone for coming tonight. Perhaps I should particularly thank the Chief Justice's wife, Valerie French, who I bet when the Chief Justice said, we're going to a launch of a curriculum review report tonight, I bet she went, I can't imagine anything I'd rather be doing. So thank you everyone for coming. And please do take a copy of the report.